The Court of Appeals is now in session.
Good morning, everyone. Welcome to the Utah Court of Appeals. I'm Judge Ryan Tenney. I'll be chairing today's panel. With me are Judges Christensen Forrester and Judge Ryan Harris. We're here today to consider three cases, the first two of which are related, Wadsworth versus Wadsworth and Wadsworth versus Wadsworth. Could we go and have attorneys make their appearances for the record before we get to the housekeeping part of this?
Julie Nelson for Appellant Candy Wadsworth. And while I'm here, Mr. Brewer is also in the room. Would you like him to join us now or second? He'll be arguing second.
I think we're okay if he just joins us for the second case.
Thank you.
Good morning. Marcy Glenn representing the cross appellant, Guy Wadsworth.
Okay, thank you. All right, so as everybody knows, we've got the two appeals. The first appeal is from the divorce proceedings, and the second appeal is regarding the security issue. We're going to argue them sequentially, but separately. And here's what I have as far as the first appeal, just to make sure that we're all on the same page as far as that goes. Because there's a cross appeal, both sides are going to get 20 minutes for argument. My understanding is that Ms. Nelson has reserved 7 minutes for rebuttal on her portion of that 20 minutes, and Ms. Glenn has reserved 5 minutes. Do I have that right so far?
Yes.
That's right. So I think the clock should show 13.
I think that's true. So we'll wait for that. While the clock is being adjusted to 13, here's my understanding of how this will proceed. So Ms. Nelson will have her time for opening. Ms. Glenn will have her time for the response, as well as the opening on her cross appeal. Ms. Nelson will have time for rebuttal on her own appeal, as well as the response on the cross appeal, and Ms. Glenn will have time then for rebuttal on the cross appeal. Do I have that right? Okay. Ms. Nelson, you're a veteran here in our court. Ms. Glenn, I don't know if this is your first time here or not. Both sides are responsible to keep track of their own time. If we keep you over, we'll be indulgent as far as extra time goes. The clock will be up on the top right. And I think that covers the bases. The only other thing that I want to make sure we get on the record, because we're doing this virtually, we'll do our best to give you some visual cue when we have questions. We'll raise our hand or make some gesture. So please pay attention to that sort of thing. If there are any connectivity issues, we'll stop the proceedings while we get those sorted out. Go ahead and text Lisa Collins and she'll get that figured out. And then the attorney who's not arguing, if you could mute yourself and hide your video, that will help us in terms of both bandwidth issues and in terms of being able to focus on the attorney arguing. Did I cover everything? Think we're good? Okay. With that, we will open argument on the first case. Ms. Nelson.
Good morning, Your Honors. Julie Nelson for Appellant Candy Wadsworth. Utah law requires that the divorce court distribute property equally in a way that facilitates a clean break and allows the parties to go forward with their separate lives on equal footing in a way that does not cause further difficulties and distress. That's what the law requires, but it is not what happened here. What happened here is the court awarded Guy control over 8/9 of the estate and awarded Candy control over 1/9 of the estate with small payments and an unsecured IOU for the rest. That does not follow Utah law, and it cannot be considered under Utah law. That division does not put the parties on equal footing. What it does is it allows Guy to use not only his share of the estate, but most of Candy's to invest, grow, spend, take tax advantages, whatever he can for that period of time, and it does not allow Candy the same. Judge Harris?
At the risk of looping Mr. Brewer into this part of the inquiry, I guess I wonder to what extent the security issues would resolve some of these concerns. Let's say hypothetically the judge had granted your motion for security, provided some mechanism for security on the, as you put it, the unsecured note. Would that make you feel better about the things you're talking about now? Would that solve some of the problems? It strikes me that at some level these two appeals do have some connectivity here.
It would make me feel somewhat better. Some is the key word. What we have here is a problem that could be solved in multiple ways. The parties could be put on equal footing in a variety of different ways. One of the main things that we asked for, and this court still can do, is award Candy more hard assets, like the restaurants, the land that the restaurants are on. It can award Candy more cash, more retirement assets. It can make larger monthly payments. It can raise the interest rate, and it can secure it. And that was something that we asked for all along, was to have the payment plan secured. But it's helpful to decrease that amount owing as much as possible and transfer to Candy in the first instance as much as possible, so that they both can enjoy and use the estate going forward equally. So yeah, security is a piece of it and certainly would help, but doesn't resolve it entirely.
Could I just ask a question? And I guess this is sort of a clarification question about, I mean, we're not talking about stocks and bonds. We're not talking about investment opportunities in the traditional sense, like assets that could be grown with smart investment. We're talking about a business. Does that change the nature of what can be awarded and how it can be divided, given that this is an ongoing business and the trial court certainly found that Mr. Wadsworth was in a better position to control and run that business going forward?
Well, let's keep in mind that there are many businesses here and they are very tangled together. Wadsworth Brothers Construction is one entity, but the restaurants are an entirely separate entity. And, you know, there's the plains and the land in North Dakota. There's all these things and they're kind of tangled together into a web. But the fact that Mr. Wadsworth has woven them together like that shouldn't prevent a divorce court from dividing them. And the idea that Mr. Wadsworth is better at managing them really isn't entirely relevant, especially when we're talking about like the restaurants. It might be relevant to Wadsworth Brothers, but like the restaurants, Candy can manage them or hire someone to manage them. Mr. Wadsworth isn't in there on a daily basis running the restaurants. And how she manages them really isn't the trial court's responsibility. The trial court's responsibility is to shift to her half of that estate and give her the ability to do that, you know, and if she sells it, that's her choice. If she runs it, that's her choice. But we've got all these different entities. It isn't only Wadsworth Brothers Construction, and I think that's important to keep in mind. This disparity in access to the estate preceded even before the decree was entered. During that 10 years of litigation, Mr. Wadsworth had access to the estate in a way that Candy did not. He had more monthly payments. Candy had about $20,000 a month, and Guy had about $140,000 a month. Guy had access to draws. He was using the entities to pay for activities, to pay for his boats and planes and things, and he wouldn't let Candy do it. And he also was able to use it for attorney fees.
Yeah, can I, given the time constraints and how much we have going on, can I take you to a particular piece of this that I'm wondering about? It's the valuation on the backlog.
Yes.
If I'm understanding the fight here, the fight is about whether and how we should be, or the district court should have been valuing future contracts. And the other side's response to your position on that, if I'm understanding it, is because the future contracts haven't been signed yet, there's nothing to value. And your response is, well, right, but of course there were going to be future contracts, so we need to value them in some form. I'm trying to figure out the mechanics of your side of that. If we don't have future contracts in place, what is the value of these contracts that don't yet exist, and how is a district court supposed to go about figuring that out?
It wasn't that they weren't signed, and it wasn't that they weren't in place. They were in place. There was $75 million worth of contracts in place. And Guy testified that he expects, you know, a certain percentage. So everybody valued it. Our expert valued that amount, the profit on that expected amount. It wasn't like the way you're describing it makes it sound more speculative than in fact it was, I think.
Okay, help me with that, because that was the piece, wading through all this. That's what I was a little bit stuck on.
Okay, so
What
these are
part did I have wrong?
contracts that WBC has signed and is working on or is planning to work on or has been awarded the bid. And so that's what WBC is going to be doing as they go forward. Just like I have cases that I'm going to be working on, but I haven't done them yet. So WBC can calculate how much it expects to spend to do those things. And it also can calculate what it expects its profit to be. And Guy testified about what that was. Guy's percentage applied to the 75 million was like about $4 million. Our expert thought it was about 3.5, and Guy's thought it was about 4.5. So everybody was on the same page that there's $75 million and we expect to profit around $4 million off of it. But what Mr. Bruff did, that was Guy's expert, what Bruff did was he decided that, well, they're going to keep having these expenses and they're going to keep having to replace their equipment. And, you know, as that happens, they're going to essentially make no profit, which just doesn't make sense. Nobody ever thought that WBC was like going into the red. No one argued that. If that had been the argument, then by all means, let's liquidate it and save ourselves the burden of doing this. But that wasn't the issue. WBC was a going concern. Everybody knew that. And so Bruff's analysis that, you know, eventually you would just spend it all off and you'd end up in the red, it just doesn't make sense. That's why we said it looks more like a liquidation value. Now, it's not like a binary check the box going concern or liquidation value, but what Bruff did looks more like a liquidation value because he expected no new contracts to be coming in and to eventually have no profit. Does that answer your question?
Yeah, I think so. Yeah.
And they did essentially the same thing with the equipment, because the equipment, they went for this auction value, which in fact, it's important to know that their expert did a hypothetical liquidation value where he talked about auctioning off the equipment. Well, that auctioning off of the equipment also looks more like a liquidation value. So our position is that they said it was a going concern, but what they did really looks like a liquidation value, and the evidence just doesn't support that.
Okay, can I ask you a question then about the equipment? If I'm understanding the case law right, we've always treated the valuation methodology question as being somewhat discretionary with the district court. Fair?
Yes.
Okay, so you probably know where I'm going with this. Maybe you've convinced me that your valuation method is better, maybe the other side has. But if this is discretionary with the district court, then the standard of review becomes something of a hurdle for you. If reasonable jurists could choose one or the other, then we, the appellate court, leave it alone. Why is the valuation method that they're proposing so wrong that it's outside the bounds of a district court's discretion?
Well, because everybody thought everybody thought that it was a going concern. And so it needs to be treated like a going concern. And those components of the backlog and the equipment really are not a going concern. And so they're inconsistent to say it's a going concern, but I'm going to call it a going concern, but what I'm really going to do is a liquidation value. That would be an abuse of discretion. If the court had just come right out and said, I'm going to do a liquidation value, then I would be here arguing that was an abuse of discretion because they weren't liquidating it. Well, you can't just get around that by calling it going concern and then in fact doing a liquidation value. And I would say that the evidence doesn't support the idea that in fact we need this liquidation value. And so that's a case where a court has abused its discretion.
Okay.
If I can get I'm running out of time fast. I want to talk about the access to the estate during the period of the divorce, where both Utah law and equity hold that this is marital money and Candy should be entitled to equal access during that period. What we need is the trial court to order Guy to disclose how much he spent. We're not asking about a revaluation of the entities or a revaluation of WBC. We just want Guy to show us how much money he spent during those 10 years so that we can make sure that Candy got an equal amount. If it turns out the amount Guy spent is the same as Candy, fine. But we know exactly how much Guy spent, and we know exactly how much Candy spent, and we have no idea how much Guy spent.
Well, why don't you know that, right? That seems like a discovery issue, right? I mean, if you had asked for that below and hadn't gotten it, you'd be appealing a particular discovery ruling, and I didn't see that in your brief. So why should we go back and allow you to make inquiry about things that happened several years ago when you should have had opportunity to do that below?
We did ask for it. Guy was obligated to disclose that information up to a certain time period. And so it's really the time period after that obligation ended that we are talking about. And we repeatedly asked the trial court to disclose how much he was spending. It wasn't a discovery issue in the sense that it was ongoing. Like, how much is he spending this month? How much is he spending this month? And we repeatedly asked the court to require him to update that spending. And that's what this court should do now. And during that period, in fact, that disparity also goes back before before the litigation really was going on, part of that period was the trust, when he was moving money out of the marital estate and making it what turned out to essentially be his separate property, because he maintained being the general manager over that trust. But Utah law doesn't allow you to convert marital property into separate property and move it outside a division of the estate. We have plenty of case law saying that you can't do that, but that's what's happened here. And so Candy should be compensated for the amount of her share of the money that was moved out of the marital estate. If there are no further questions, I think I will reserve the remainder of my time for rebuttal.
Actually, can I ask you a question? Sorry, you were just in the process of sitting down. There is this sort of lingering question. It bleeds over into the second appeal about whether the equalization payment plan that Judge Chan adopted was an abuse of her discretion. You're conceding, I think, that equalization plans can be imposed as part of divorce proceedings. You're just saying this one doesn't work, right?
Right. An equalization plan that puts the parties on equal footing would be fine and necessary.
And it seems to me that a key part of your argument has to do with the delay, right? It's the 5-year component.
That's one part. This is the same answer I gave to Judge Harris. Like, the security is a problem, the 5 years is a problem, the minimum payments is a problem, the lack of handing assets over is a problem. So can we fix it by fixing one thing? I mean, maybe, but we're looking for a different configuration that puts Candy on equal footing with Guy.
One of the things that I'm then struggling with as far as this case, and this isn't your issue, or it just is unique to this case, is how do we write that rule? I mean, to the extent that the time is the problem, jurisprudentially, what does the rule look like there? 1 year is okay, but 5's not. Walk me through that part.
The rule doesn't have to be about time, and it doesn't have to be about an interest rate. The rule can be pulled from other aspects of marital case law in this state that says the parties need to be on equal footing. They need to go forward with as clean a break as possible. They need to not have further difficulties and distress, and they need to be able to go forward with their separate lives. So what we need is a rule that requires that the recipient of a payment plan is somehow benefiting from the estate in the same way that the holder of the money is. So, whether you do that by having like a special master decide who gets what, or whether you do that by increasing the monthly payment. I mean, the monthly payment here was half of Guy's discretionary income. That's where that number comes from. It's half of Guy's discretionary income. It leaves him another $25,000 in discretionary income. Meanwhile, Candy is not able to benefit from her $15 million. So your rule just needs to be that the parties need to be put on equal footing, and Judge Chan abused her discretion by creating a plan that is so heavily skewed in Guy's favor.
Okay, that makes sense. Thank you.
Now I'll reserve the remainder of my time for rebuttal.
Ms. Glenn.
Thank you. As this court knows well, in divorce cases, trial courts have two primary responsibilities: to apply the law correctly, and above all, to do equity. In this case, which has been long, contentious, and complex, the trial court discharged those responsibilities quite well. Guy did not like many of the trial court's rulings, but he accepted them as within the trial court's discretion, noting the point that Judge Tenney made. However, the trial court made two decisions that unfairly burden Guy and create windfalls for Candy. The trial court effectively gave Candy substantially more than half of the marital estate, and that's not fair. It's the other side of the coin that Ms. Nelson argued. And the trial court also awarded alimony to Candy when she does not need any alimony to meet her needs, to live at the standard she lived at during the marriage. And I'm not talking about unfairness around the margins. These rulings caused such serious inequity as to rise to the level of abuses of discretion, and they are the subjects of Guy's cross appeal. Today, I'd like to focus on those issues. They will include the issue in the main appeal of whether an equalization payment was permitted at all. But for the remainder of the issues that Candy raises in her appeal, with the court's permission, we would rely on our principal brief because I've listened to the argument and I believe that we have addressed all the points that Ms. Nelson makes today already in our brief. Beginning with division of the
Ms.
estate, the
Glenn.
trial court, I'm sorry, Judge Tenney.
Right. Can I just ask perhaps it's a small question, but it's about the last point that you were making about her demonstration of need. It seems to me that there's something of a disconnect in your position on alimony, which is that on the one hand, you fault her for not providing enough information about her needs. But then on the other hand, your argument on alimony seems to be that she shouldn't get alimony because she doesn't need the extra money. And it seems to me that those are in something of tension. If we don't know what her needs are, then how do you show that she doesn't need alimony?
Sure. Well, I can address that. There are really two parts to our she doesn't need alimony argument. And one part is, as you said, what is her need? And the second part, though, is does she have enough monthly income to meet that need, whatever it is? So the court decided that her monthly need was $27,000. We believe that was an abuse of discretion for the reasons we've argued, because she didn't steadfastly refuse to submit a completed financial affidavit. And we don't believe that she submitted adequate financial documentation or testimony for the court to impute the various needs that it did. But we can leave that aside. We can assume for purposes of argument that her needs are about $27,000 a month. And she hasn't challenged that on appeal except in two very limited respects, having to do with taxes, taxes on her alimony, and life insurance, which don't really, the tax issue does affect the number. But even if we say it should be higher than $27,000 because we assume she's correct on the taxes on her alimony point, which we do not believe for many reasons, let's just assume the need. Our point is that she undisputably receives about $71,500, $71,500 in interest income every month. That's the interest that Guy has been ordered to pay on the balloon payment, on the equalization payment. $30,000 a month plus $500,000 at the end of the year, which breaks down to about $41,500 per month. What we're saying is that if you just look at that interest income, ignore for now her imputed income of somewhere around $2,000, ignore for now whatever investment income she could earn off of the portion of the $6.4 million of the marital assets that she received that are liquid assets and investable. But just focusing on that $71,500, it's more than enough to meet her needs, whether they are $27,000, $30,000. So you're right. We don't really know what her needs are. We suspect they're less than $27,000, but perhaps they're a little bit more. Regardless, she has the money to meet those needs. That's our alimony argument.
Isn't the needs assessment to be made, though, in the context of the marital standard of living? And it doesn't seem, or it seems, and maybe I'm wrong here, but that it's fairly obvious that $27,000 a month is different than what was going on while these parties were married.
Well, I don't
So
think
do you have to contrast it like that or no?
Well, I think that the standard is that her needs have to be measured by the standard when they were married. But one other fact I'd like to mention is that she also lives debt-free. Guy paid off the mortgage on her prior home, so she was able to pay cash for her current home. He paid off anything having to do with her cars, bought her a second luxury vehicle in 2014, well into the divorce proceedings. But getting back to your question, Your Honor, I'm not sure that many people would think that you can't live an awfully comfortable life on $27,000 a month. I certainly could. And so it may be
But
less.
we're not talking about if I could live on $27,000
Right.
a month. We're talking about the standard of living that was generated during this 30-year marriage.
And I would just say that Candy has not raised on appeal any issue related to whether or not that amount is adequate to meet her standard of living, other than as it relates to the alimony taxation question. So I haven't heard her say, I don't have enough to buy the clothes that I used to buy. I don't have enough to do the travel I used to do and so forth in this appeal. So we think that she's got the money that she needs to live comfortably. Of course, she has not only the 27,000 now, she has the 71.5 plus other income that we haven't included in that. If there are no more questions right now on alimony, I'll return to the division of the estate. And as Ms. Nelson indicated, she doesn't object to equalization payments in the abstract, only to this one. I'd like to just, for context, review the reasons why the court ordered an equalization payment, which are all supported by findings in the record. First, the fact that the bulk of the estate is illiquid, as the court's questions recognize. It's about a $44 million estate. Of that, about $32 million consists of business assets. $23 million is the value of Wadsworth Brothers Construction, which is the main business asset, WBC. There are other businesses that are auxiliary entities that service the needs of Wadsworth Brothers and are essential to its business, like the equipment company, which receives depreciated equipment. Yes, Judge Tenney.
Can I ask you a question? This is sort of a big picture question about this. If you've acknowledged here, and you also did in your brief, that at some point he's going to have to find a way to liquidate some of these assets. I mean, you say this very directly on page 72 of your brief. Then we get to the 5-year problem. And I understand Ms. Nelson's point in the briefing and today, part of it to be, look, if one of the driving goals of divorce is to separate the parties and allow them to move on. And if you're acknowledging that at some point he's going to have to find a way to liquidate these otherwise illiquid assets, why does he get 5 years to do that? Why isn't it an abuse of discretion to give him that much time as opposed to, say, 6 months or a year? I mean, to me, this timing is really the hinge point for a lot of this. If the court had just said, I'm going to give you 12 months to figure out the way to liquidate this thing that you're saying you acknowledge you have to liquidate, this case feels very different to me than this 5-year part. Tell me why the 5-year part's okay.
Well, I think that what's going on here, and this is one of the reasons for the equalization payment in the first place, is that not only are the assets illiquid and indivisible because Candy was not qualified to co-own them with Guy and co-operate them, but they are essentially, the assets are the goose that lays the golden eggs, is the best way I can put it. The assets, particularly WBC and the related assets, are in good years, profitable entities. They are the source of Guy's salary. They are the source of draws and distributions that Guy used to support their lifestyle.
I understand that completely. I guess my question is, if at some point he's going to have to sell, he's going to have to slay the goose that lays the golden egg at some point, what changes in 5 years that doesn't change in 12 months, if he's going to have to do eventually anyway?
Sure. I think that perhaps what the court was thinking, and I don't think it's reflected in a finding, but I think it can be inferred as a subsidiary reasoning, is that the court wanted to let these businesses continue to generate income and sustain this lifestyle for some reasonable period of time. Now, Guy is not a spring chicken, going back to golden eggs and so forth, but the court may have decided that 5 years was a reasonable period of time to require Guy to defer retirement and continue generating income to help support, to kind of fuel this engine. And that could have been the reason, but I think the real question, the court could have ordered dissipation, could have ordered the parties to sell the assets, all of them, prior to entering the decree or in a shorter period of time. But the real question for this court is whether it was an abuse of discretion to instead pick the 5-year period. And the court's cases don't indicate any set period of time. I mean, in Taft, it was a 10-year period and there were problems with that, but not based on the duration of the period all by itself. In Mariquin, there was actually no deadline for when the equalization payment would be paid. So I think it has to be very case specific. And in this case, the court apparently concluded that 5 years was a reasonable period of time for Guy to continue operating the businesses, paying Candy a hefty interest payment each month to allow her to continue living at her previous standard. And after 5 years, he'd have to figure it out. It was also a period of time in which he could position the businesses for eventual sale, which he is doing as we speak, growing them, continuing to grow them so that he can recover the maximum amount when they are sold and pay the equalization payment. So that's the best answer I can give you. The record does not tell us more about why the court selected 5 years over, say, 3 years or 1 year. No party selected a different period of time, I would just note, other than Candy's request that there be no period of time and that she be paid immediately. I would note, and this relates to our cross appeal, that if the court had done that, I'm sorry.
I was just I was gonna ask you a question about the possible liquidation, not about the time period necessarily, but with the understanding that liquidation is something that's going to have to happen. Are you arguing, is your argument on that the court abused its discretion in failing to consider the sort of the liquidation costs and the tax burdens, that the court allocated that liability only to Guy? Is your argument that the court didn't make adequate factual findings about to justify no discussion of that potential liability, or is it that in a way Guy didn't actually ask for, Mr. Wadsworth didn't actually ask for the court to do that?
Well, our briefs do talk about factual findings, but actually we're asking this court to order more than that, more than a remand for factual findings. We are asking the court to say that it was an abuse of discretion not to take into consideration those transaction costs and actually enter an order supported by factual findings that would require Candy to share in those transaction costs if Guy must sell business assets in order to fund any part of the equalization payment to her. And we would expect the trial court's order to make clear that she would only be responsible for those costs to the extent that those proceeds from the sale of the assets actually contribute to the equalization payment. That's what we're asking for. My time is up, and unless the court has questions, I will save the remainder of my argument for rebuttal.
No, seeing none. We'll return to Ms. Nelson. Thank you.
Thank you. Julie Nelson for appellant Candy Wadsworth. The question is not about whether Candy has a lot of money. The question is about whether Candy has the same amount as Guy, and she doesn't. And Guy has never argued that she does, and he has never offered a plan about how to get it to her. Literally, his plan was to pay her $3,000 a month. Even now, he can't come up with a plan. But divorce law requires that Candy be awarded half of the estate. And it's normally supposed to be done close to the decree as you can get. Now, Judge Tenney has said, what if it was 6 months? That would have made us feel a lot better. That would have been over a year and a half ago. But as it is, it's extended out to December 2024. It's unsecured. We have no idea what's going to happen. And in the meantime, Guy can use it. And we know that he's using it. We have in the record, in the affidavit that Candy provided at the very end, he's building an elaborate wedding venue at Tuscany. He's also buying himself $250,000 cars. Like, he is benefiting from the estate in a way that Candy is not. Utah law does not allow that. We see it in Taft paragraph 59. We see it in Jones. the old Jones, Utah, 1985, 700 P. 2nd, 1072. I'm going to read to you. I hate to read, but the trial court should not permit all claims of need for capital on the part of the business to take precedence over the support needs of the wife. If these capital needs are a result of discretionary decisions of the husband to expand and improve the business, rather than to maintain it in its present condition, then to permit him to divert income into the business at the expense of his ex-spouse's support needs would be to permit him to enrich himself at her expense. We see the exact same thing in Taft paragraph 59, talking about how the husband has full enjoyment from the date of the decree and the wife does not. That's what we have here. Their alimony argument hits the same point. Guy has not only his own income, but all of the money to work with. Candy doesn't. She does not have all of the money to work with. She can't decide how to manage it. She can't decide what to buy. She can't decide to buy a different house. She's just limited to that monthly payment. That's why their alimony argument fails and why it failed in front of Judge Chan. This is like the minimum way that Candy starts to get some of the property. They've briefly touched on Candy's taxes issue in the alimony. I think we can rely on our briefing, but I would like to point out that that December 2018 decree, the only operative point from it was that the alimony would start and therefore Candy would have to pay taxes. Everything else became operative in October 2019, including the payment plan, including the post-judgment rate that they argue is appropriate. That's an October 2019 issue. The only thing that stayed relevant was that Candy has to pay taxes on her alimony. I guess the overall summary here is that Guy is able to use the marital estate to supplement his lifestyle and Candy is not. There are a number of other issues from our briefing that have not been touched on, and perhaps I'll use this time to talk about some of them. Judge Harris.
Yeah, can you respond to the transaction costs issue that Ms. Glenn raised? So, when the time comes that Guy, whether it's next month or in 5 years, that Guy has to sell some of these assets to make the equalization payment, there will be some transaction costs. I think everybody kind of assumes that. I think it would be quite a shock if there weren't. Why shouldn't your client have to bear at least some portion or some equitable portion of those transaction costs?
For several reasons. One is that some of those transaction costs didn't even need to occur. If the court had had given Candy assets right off the bat, then there would be no transaction costs. There are no transaction costs in simply shifting to the other spouse. So that should be minimized as much as possible. And the transaction costs just point out how ridiculous it is that Guy's been given all of the assets to manage and now is asking for Candy to have to bear part of the cost. That's one reason. Another reason is that if in fact he's going to liquidate, which I don't think was clear at trial. I think at trial, the idea was that he would use it to grow and benefit, and maybe in 5 years, the estate will be worth even more money, and then he'll be able to give it to Candy, no problem. We assume that's what he's doing with these 5 years. If that's not what he's doing, then by all means, we should go with what Judge Tenney is saying and accelerate that plan so that we can give Candy her share as quickly as possible. But they never asked for that. And they never asked for liquidation value. They resisted it. They resisted every sort of payment to Candy. And the third reason that Candy shouldn't have to bear any of the liquidation costs is that Utah law doesn't require it when liquidation is speculative. Utah law is very clear that in a division of assets, if transaction costs are going to be speculative, that's the key word, speculative, then they don't need to be incorporated. And we hear Ms. Glenn saying today, and she said in her brief, if and when Guy has to liquidate. If means speculative. If we knew what he was going to liquidate or he knew when he was going to do it, then that would be an entirely different payment plan. But the courts left him all the discretion. One thing we asked for at trial was a special master to oversee the liquidation, to make sure that things were liquidated in a timely manner and for fair market value. We certainly don't have any ability right now to see whether what he does is fair market value. And we asked for those kinds of protections to be put in place to make sure that the payment plan, the equalization note system, could be acceptable. But that was all rejected. And that's they go together about whether this equalization plan is acceptable ties into what they're arguing about the liquidation costs. Well, the reason that the equalization plan was even established was to prevent liquidation costs like that. So the problems can be solved simultaneously, and they ought to be solved simultaneously, and they ought not to be looked at as different boxes. They come together.
No, go.
Well, I guess in other words, let's leave Wadsworth Brothers Construction, sort of the big company, let's leave that aside for a moment. I think that raises a different question, but let's focus on some of the smaller businesses. Let's say that he decides he needs to sell the restaurant entity. And I think part of what you're saying, if I'm hearing you correctly, is that rather than sell it to a third party and incur a bunch of transaction costs, why doesn't he just give it to your client?
Absolutely. Absolutely.
In that instance, there would be zero transaction costs, and that would be more efficient, and it would solve some of these problems. Is that what I hear you saying?
Yes. 100%, that's what I'm saying. As many of those assets as can be moved over should be, but not just like not just the bad losing assets. It needs to be divided equally. So the restaurants and the land that the restaurants are on has always been the thing that we have suggested should be shifted over. But there's other things like his retirement account. Okay, that can be moved over. There's no transaction cost there. He's got plenty of money coming out of WBC. That whole plan could be divided differently so that she was given more money up front to reduce these kinds of costs and whatever things may possibly arise. Judge Tenning, was that also your question?
Yeah, I covered it.
If there are no further questions, we ask this court to reverse and remand. I know that at the end of our reply brief, we listed out the issues and our requested relief to help you work your way through these issues. On the other points, we'll submit on our briefs.
Actually, can I ask, sorry, I'm going to do this twice. Can I ask you a question while you're sitting down? Is there a way to write this opinion that doesn't prompt another 3 years of litigation? I mean, this is kind of a big picture question, but there's so many pieces, there's so many moving parts to this. And so you sort of got this big picture problem, which is that Judge Chon didn't make things equal. And short of us just writing the new divorce order, I just worry that however we do this, we're going to send it back and we're going to have another 3 years of fighting about that. How do you propose that we go about solving that problem if we agree with you that things weren't equal?
Well, I mean, we'd be happy for you to go ahead and write the new divorce decree. That would be great. Or give extremely clear instructions on how the new divorce decree should be written to avoid some of this. But you're right, some of this litigation will continue because it wasn't handled properly the first time, and that's unfortunate. It is. But I guess I would.
But I think that runs to Ms. Glenn's point, though, which is that if you've got this range of options in front of the district court, and some of them are better or worse than others, short of us just picking the options ourselves, we end up back at an abuse of discretion problem, which is the Judge Chon looked at the same set of options and said, this 5-year period in the equalization payment, this is the best of these options, and this is what we're going to do with that. And I just don't know quite how to get through the abuse of discretion standard, short of us just writing the divorce decree ourselves. Help me with that.
Okay, so I accept that you don't want to write the divorce decree yourselves.
Right.
I think that what needs to happen is that this court needs to make it very clear that a property distribution needs to provide equal access to the estate, and that this one doesn't do it. The only way, there are many ways to do it, and those would be discretionary. But if you make it so that the parties don't have equal access to the estate, then that is an abuse of discretion. And that's the rule that has to go forward. And so in order to facilitate that here, you move over the restaurants, you move over the land, you move over whatever else is liquid that can be moved, you increase the monthly payments, the 5-year payment plan is okay if it's working towards the goal of increasing the overall estate so that the payment plan can be executed properly and it's secured. But if not, if we're going to end up liquidating, then let's do it. Let's go ahead and liquidate. Let's end the litigation. Let's sell everything off, give her money, and move forward. I mean, the 3-year timeline that you proposed is kind of a painful timeline because that's actually how much longer Candy is supposed to wait for her money. That entire period, she would just be waiting, hoping that in December 2024, he's going to make his payment. And that's just inherently inequitable. And that's where we get to an abuse of discretion. Taft doesn't allow it. Jones doesn't allow it. I think we see it from Dahl. It just doesn't allow it. You cannot divide the estate this way.
Okay.
Those need to be your instructions.
All right, unless there are further questions, I think we're good. Thank you. Ms. Glenn.
Thank you. You know, Ms. Nelson's remarks alluded to a couple of other options that the trial court could have taken. And it could have ordered the sale of all the assets.
Can you hang on for
I'm
just a
sorry.
second until we get our clock straightened out?
Oh, sure. I'm sorry.
All right. There we go.
Okay. The court could have ordered the sale of all the business assets before it entered the decree. If it had done that, the proceeds would have been net proceeds, net of liquidation costs, and Candy would have shared equally in those costs. The court could have given Candy more of the business assets, as she says it should have. Candy's complaint seems to be that she wants more money. So presumably soon after receiving those assets or at some point in time, she would sell those assets. And then she would incur 100% of the transaction costs that we're talking about in connection with those assets. And so really her suggestions for what the court should have done instead of ordering an equalization payment really help explain why it's so fundamentally unfair that Guy alone is saddled with those costs under the equalization payment. And we're not talking about small costs. I mean, we do have the trial evidence that WBC alone was valued at about $11.7 million for Candy, for Guy. So you double that to get its total value of over $23 million. Of Guy's $11.7 million, his expert predicts that the taxes and other transaction costs upon sale will be about close to $7 million, meaning that Guy's 11.7 will drop to 4.7, while Candy, meanwhile, will still be entitled to her 11.7 million, which will be part of the balloon payment that Guy will continue to owe her. So this is a very real issue for Guy. Just a couple of notes I wanted to make in response to some points that were made about the alternatives. Ms. Nelson challenges the notion of imposing these transaction costs because Utah law prohibits the award of speculative costs. We agree. And that's why Guy is not requesting the court to order Candy's payment of any certain amount. The court will have continuing jurisdiction over this decree, even when the parties finally do settle their disagreements, Judge Tenney, and the court is in a position to make sure that Candy is only allotted those transaction costs that fairly relate to the sale of assets to pay her specific parts of the balloon payment. This estate is what it is. This goes back to Ms. Nelson's general complaint that the court entered an equalization payment order. None of us has any control over the composition of this marital estate. It is illiquid, it is indivisible, it is profitable only if Guy is able to continue running WBC as he has in the past.
But it has to be liquid at some point. I mean, this comes back to what you and I had earlier. If it has to be liquid at some point,
it absolutely does.
If she's entitled to half of it, why does he get it for this much time without her having access to it in the same way that he does?
That's what happens whenever there is an equalization payment that is deferred. You could ask that question in Mariquin and Taft and the other cases, Argyle and Pope, that have approved the use of equalization payments. There were good reasons in this case for that deferral of the moment of liquidation. It's possible that things will go really well and Guy will not need to liquidate the businesses eventually. We don't think that will be the way it turns out, but that's certainly a possibility. But the court found that there were good reasons to do it. And as you have asked in some of your questions, the only issue for this court is whether that was an abuse of the trial court's discretion. We know that equalization payments are permitted under Utah law. It's always going to be case specific about whether it makes sense and whether the court had good reasons for ordering it in the particular case. We submit that there were good reasons in this case, and that Judge Chan articulated those good reasons time and again in response to the parties' various motions post the divorce trial. I have 10 seconds. I think I may just let it be at this point, unless the court has other questions.
No.
Thank you very
Seeing-
much for your time.
Seeing none, we'll have the case submitted. Ms. Nelson, if you could reappear just momentarily. Thank you both for your arguments and your briefing. This is an extraordinarily complex case. Personally, I found the briefing to be very, very helpful in sorting through all this. I think we're gonna close this link now, and then we're all gonna gather again for the next argument in the related appeal.
Thank
Okay.
you.
Thank you.